that went to any potential bias from pretrial publicity, as well as the sources and the amount of pretrial publicity that each prospective juror had seen. There was follow-up questioning in the individualized voir dire about that particular question, question 77, with virtually every prospective juror and all the seated jurors. None of the seated jurors expressed a predisposition to impose a capital sentence, which is the only thing at issue.
All that makes sense, but I'm looking more for the standard that you would apply. What would be your rule, assuming you accept, to some extent, the supervisory authority of the First Circuit? What would be your rule for reviewing the exercise of that authority?
Your Honor, I think if the court accepts that the Court of Appeals can dictate to district courts how to do this, I think this court ought to just be reviewing the rule to see whether that was a sound and reasonable exercise of the rule, bearing in mind that it is an exercise of supervisory power that the Court of Appeals is imposing in a context where district courts have the utmost discretion.
Do you think, would we review it as the First Circuit exceeding its supervisory authority, in the sense that normally that authority is exercised, say, on local procedures or something like that? Or are you saying that we should review it in this area for something like reasonableness?
Well, Your Honor, I think you could do, frankly, either. I think at the threshold, the court ought to ask whether the Court of Appeals exceeded its authority in even enacting such a rule. If you look at the court's decision in Painter, it is a clear expression by this court that courts of appeals shouldn't invoke their supervisory power as an end around to the reasoning of this court, which is, I think, what the Court of Appeals has done here. The second way you could look at it, Justice Thomas, is more of a whether, assuming it actually had the authority to do this, should it have done so? And I think if you look at this court's other supervisory rule decisions, where even accepting the Court of Appeals might have had the authority to enact some rules in this area, enacting a hard and fast rule like this that would at least be rigid enough to divest the experienced district judge in this case of his sound discretion to determine that these questions wouldn't be a helpful addition to the mix of information already available to the parties, and that it could be addressed through individualized voir dire, and that the questions might even be counterproductive by focusing the prospective jurors on something that the judge was at the same time instructing them that they should disregard. To the extent the rule is that wooden and that rigid, it is an unreasonable supervisory rule, Justice Thomas.
To go back to the beginning of your answer to Justice Thomas, do you dispute the authority of the Courts of Appeals to issue some requirements under their supervisory power?
Certainly not as a general matter, Your Honor. I think it's a little bit more circumscribed when it comes to jury selection procedures because of this Court's repeated emphasis on the discretion that district courts necessarily have to have.
Where does that authority come from?
Your Honor, we're following this Court's cases which appear to presume that this Court has some supervisory power and haven't especially—
Well, our supervisory power would be different than the Court of Appeals' supervisory power over district courts, right? Are you just, because we've assumed in some cases that courts of appeals have it, relying on our precedents?
Yeah, Your Honor, we haven't questioned whether courts of appeals generally have supervisory power. I suppose one other way to decide this case in the government's favor would be to take issue with that, but we haven't questioned that specifically.
Mr. Fagan, if we took question with that, it would upend a whole bunch of rules, some of which in Moonbeam itself we endorsed. But there are local rules about making sure that a pro se prisoner knows that he or she, what rights they're giving up if they're going to proceed pro se. There are local rules on what you have to do if you're going to dismiss a complaint, letting pro se litigants have an opportunity to cure their deficiency. We have local rules on waivers of all kinds, including jury waivers. There's a whole lot of local rules that talk about what courts are thinking about as adequate process, and they're not changing outcomes. They're just saying to courts, before you exercise your discretion, make sure that these things have happened.
Well,
so are you suggesting that we should take aim at those local rules?
No, Your Honor. Let me just emphasize two quick points. As I emphasized to Justice Barrett, we haven't questioned the Court of Appeals supervisory authority in this case.
Mu Ming, I think it said, did we spend, I think, 2 or 3 paragraphs talking about local rules?
Well, Your Honor, the other point I was going to make in response to your original question before I get to that specifically is we're also not questioning, I didn't take Justice Barrett's question to get at the separate issue of, for example, local rules that district courts enact for themselves. However, in Mu Min, the court did note the existence of some supervisory rules in this context. There might be a question as to how far each of those rules at the time of Mu Min would have extended and whether they would have covered this case. But I think the reasoning of Mu Min, again, I'd point the court back to page 424 of that decision, makes clear that in exercising its own supervisory power, this court has not dictated specific forms of questioning, even in the most sensitive context of race with the supervisory rule adopted by the plurality in Rosales-Lopez. I think it was inappropriate for the Court of Appeals here to have a rigid wooden rule that dictates specific questioning.
It wasn't all that rigid. The rule was very simply stated in Patriarch, which was ask some questions about the kind and degree of publicity that's out there. And the court permitted degree. It permitted people to tell how much they had read, a little, a lot, or a moderate amount. But it didn't permit questioning as to what kind of publicity, because there was a whole lot of different publicity here. There was publicity on the day of the event. There was publicity the days after. There was publicity about what major politicians and others were suggesting the punishment should be. There were interviews of victims. There was a whole lot of different kinds of publicity. And the district court and the government objected when counsel attempted to elicit that kind of information. That seems like an extreme control over trying to figure out whether someone could have been influenced by that publicity.
Well, a few points, Justice Sotomayor. First of all, the government did not always object, and if you look at pages 733 to 735 of the Court of Appeals appendix in this case, you'll see the district court emphasizing that these questions would be allowable on a juror-specific basis depending on the kinds of answers the juror had previously given. As to the different kinds of publicity, Justice Sotomayor, they didn't request any questions asking whether jurors had seen specific types of publicity. And I think the reason they didn't do that is because they didn't want to focus the jurors on those kinds of things, like what opinions people might have expressed about the death penalty in this case.
So what was wrong with the one question they wanted to ask? What stands out in your mind about all that publicity? It seems to me that that's not asking for details of everything you've read, but what has influenced you or affected you enough for you to remember it.
Well, I think
that seems like a totally appropriate question to me.
I think as Respondent's own counsel pointed out, and this is at page 480 of the joint appendix, a question like that is unlikely to be particularly useful in a case like this because everyone saw the same coverage, so they were all going to say the same things. The carnage at the finish line, the chase in Watertown, the killing of Officer Collier, the boat manifesto.
Well,
that
doesn't it
respondent
tell
wrote.
you something, someone who says something else? How
Well-
about if you ask a juror that and the juror says, I listened to victim X, and that has haunted me? That certainly would be information relevant to a defense attorney and even to the prosecution.
Well, Your Honor, I think I'd push back a little bit on whether on the idea that there wasn't questioning that got at the kinds of publicity that the jurors had seen. Many of the jurors volunteered such information. There were occasions when Respondent's Counsel was able to ask that question, or there was some other revelation of some media coverage that some particular juror had seen. The jurors were extensively questioned on their views on the death penalty in particular, and if the jurors were biased on that by something, that might have itself come out in the course of that question.
Mr.
Counsel, we call this, it's been called a supervisory rule. Now, if I'm going to argue a case in a circuit court of appeal, you look at the rules, there's usually a little pamphlet telling you these are the circuit rules. They may be supplemental to the Court of Appeals rules. What makes this a rule? It seems to me that it's really nothing more or less than a precedent. I mean, is there a collection of these supervisory rules somewhere? This is Rule 22? What?
Well, Your Honor, I don't think I'm going to really dispute what you just said. I think everyone was actually taken by surprise that there even was such a thing as the patriarchal rule, given that no one had cited it in the district court, including the Court of Appeals itself when it was reviewing jury selection procedures in a mandamus petition about venue. It praised the jury selection procedures and never once mentioned
should we consider this requirement in any way different from the way we consider any precedent because it's labeled a supervisory rule?
If anything, Your Honor, I would give it less weight because it was dictum in Patriarcha itself, which simply affirmed the denial of a venue change. So I really don't think...
If we issue an opinion and we write it and it has a particular holding, I think the author would probably be very happy to say, our rule going forward is this. But that's just saying it's a precedent. I don't know attaching a label to it. I mean, Justice Sotomayor is right. There are circuit rules governing a lot of things, and from minor, filed your application on 8.5 by 11 paper to more significant things. But this is a rule of law. I don't see what's gained by calling it a rule, a supervisory rule.
I agree with that, Your Honor. I think the reason for labeling it such and the reason certain things are labeled supervisory rules is there are advisories going forward to in this instance, district courts to tell them that if they do not do something in the future, they will be reversed for not doing it.
Well, we tell them that, too, that if they don't follow this particular rule of law in the future, they'll be reversed. I don't know that every one of our cases governing district court practice is a supervisory rule.
I think it is particularly geared toward areas like case management where they're just trying to put district courts on notice. I think that is actually a fairly poor characterization of Patriarcha itself, which, as I said, kind of renders this as something of an advisory note at the end of deciding something else. So I'm not even sure.
Isn't the distinction that it's not based on the Constitution and it's not based on a statute or a regulation? It is a prophylactic rule that is adopted by the court for the purpose of protecting a constitutional right. But it isn't. The proposition is not that this is required by the Constitution. Is that the distinction?
Well, it's not. I think that is one distinction. It's not required by the Constitution. The Court's drawn that distinction in this particular line of cases where it's been somewhat stricter in reviewing federal courts than it has been in reviewing state courts. That's quite clear from for example, Moomin. And if one accepts that courts of appeals can impose their own supervisory rules in this context, I think what they're labeling a supervisory rule is just, as I was telling the Chief Justice, just an advisement to district courts that this is how you should do it. But I think it definitely exceeds a court of appeals authority to impose such a rule that contradicts the way that this court has handled similar situations.
Mr. Fagan, can I turn to the evidentiary question in this case? I've been having a little bit of a difficult time teasing apart your various arguments about why it is that the district court acted within its discretion in refusing to admit the evidence about Tamerlane's participation in the Waltham murders. So I just thought I'd give you a little bit of a hypothetical. Or maybe it's not a hypothetical, maybe it's just asking you to assume something that you contest, which is assume for me that the evidence was very strong that Tamerlane participated in and indeed had a leading role in the Waltham murders. All right, so assume that the evidence is strong with respect to that. In that case, would the court have committed reversible error by refusing to admit that evidence?
Your Honor, I think that would be a much more difficult case for us.
Yes, I'm just asking, in that difficult case, would the court have committed reversible error?
Well, Your Honor, assuming, and one point I want to emphasize is that in district court here, they did not assert, this is pages 668
Mr. Fagan,
669.
could you just answer the question?
Your Honor, one point I'm trying to make is it would depend whether there was some assertion that respondent was aware of it, which is an assertion they did not make in district court. But
sorry, I thought they did, but it was earlier in the case.
Let's just assume, yes. I'm saying, you know, the defendant was aware of it. Now answer the question.
If the defendant was aware of it and there was strong evidence of it, I think the district court should have let it in.
Okay.
Neither of those was true here.
I assume that you say that because the evidence, assuming it was strong, the evidence clearly is, you know, goes to a mitigating factor. The entire point of the defendant's mitigation case was that he was, you know, dominated by, unduly influenced by his older brother. And that would have gone to exactly that point. Is that right?
Your Honor, if you had the knowledge combined with the strong evidence, I think that might well have done it, particularly if it could have been done in a streamlined fashion. But if you look at pages 668 to 669.
If that's true, Mr. Fagan,
yeah,
then your entire case rests on the notion that this evidence just wasn't strong enough, that it was too, I don't know what else to call it. It didn't establish that Tamerlane had played a leading role in the Waltham murders. That's what your case is. But how is that the job of a district court to evaluate, much less decide, that question? I would have thought that once the district court says this is obviously related to his sentencing defense, in other words, it goes to his own culpability, it essentially confirms, if it were true, the mitigating factor that he was unduly influenced by his brother. At that point, it's the job of the jury, isn't it, to decide on the reliability of the evidence, to decide whether it's strong evidence or weak evidence that Tamerlane, in fact, played a leading role in those other gruesome murders?
Your Honor, just a very quick threshold point. Again, there is the knowledge issue here, and if you look at pages 668, 669, you'll see they didn't.
I'm assuming the knowledge issue
in the district court. Assuming knowledge, then I think
I don't even know that knowledge is all that important, because even if he didn't know, the fact that his brother was the kind of person who played this leading role in these gruesome murders tells you something about the role he might have played in this murder, irrespective of knowledge. But at any rate, let's just assume that he had knowledge.
So let me just say a couple things directly responsive to your question. One is everyone agrees that reliability is an important consideration here. If you look at pages 16 to 17 of their brief, page 30 of their brief, they agree with that. Then you have to balance that against the probative value of this evidence. And I don't think the evidence really would have added much to the mix of information we already had about, for example, who planned the Boston Marathon bombing.
I mean, think about what you're just saying, Mr. Fagan. This court let in evidence about Tamerlane poking somebody in the chest. This court let in evidence about Tamerlane shouting at people. This court let in evidence about Tamerlane assaulting a former student, a fellow student, all because that showed what kind of person Tamerlane was and what kind of influence he might have had over his brother. And yet this court kept out evidence that Tamerlane led a crime that resulted in 3 murders?
May I respond, Mr. Chief Justice?
Certainly.
Your Honor, I think the one thing to bear in mind is these crimes are extremely different. They have the Waltham crime, everyone agrees, did not involve respondent. It was very differently motivated. It was, even if you accept everything Tudashev said, it was a financial crime where the murder was committed by knife in order to cover up who had committed the robbery of 3 drug dealers. That is a far cry from a sophisticated public spectacle that required reading directions in a jihadist magazine on how to build and construct bombs and deliberately placing them at the finish line of the Boston Marathon.
It's different that Tamerlane yelled in a mosque, and it's different that Tamerlane assaulted a fellow student, and it's different that Tamerlane yelled at people. But all of this was admitted to show what kind of person Tamerlane was and what kind of influence he had over his brother. And yet, the court, again, refuses to admit evidence of a gruesome, murderous crime in which, according to the evidence that was kept out, Tamerlane had extraordinary influence over a co-felon in getting him to murder 3 people.
Your Honor, Tudashev denied murdering. He says he was out by the CRV when all of this happened. And this is very unreliable evidence because Tudashev had every incentive to pin this entire thing on Tamerlane, who at that point was already dead, and they knew they were looking for him. I'd encourage the court to read the transcript of the interview. According to Tudashev, and I think this is page 947 of the Joint Appendix, Tamerlane says to him, okay, if you will not kill them, I will do it.
Isn't that exactly the kind of thing that the prosecutor would have said to the jury about why they shouldn't believe that evidence? But isn't this a classic case in which the evidence understood one way is highly relevant to a mitigation defense, and the evidence understood in the way you just suggested, just says that's crazy. It didn't happen that way. But that's what a jury is supposed to do, isn't it?
Your Honor, unlike the other evidence that you have cited, there was going to be no cross-examination here. The only people who might have known what happened in Waltham were Tudashev, who admitted to some participation, and possibly Tamerlane, and both of them were dead. This investigation had hit the end of the road. There was no way to figure out what happened. The district court reasonably determined that. We're here on abuse of discretion review. And moreover, I think everyone agrees that this is subject to harmless error analysis. And if you look at all the other details that the jury heard, and I'm happy to list them all.
Mr. Fagan, along the same lines, you say on page 39 of your brief that under the Federal Death Penalty Act, the countervailing interests that would justify excluding evidence, you can do that if they outweigh the information's probative value. And you note that, on the other hand, under the Federal Rule of Evidence, if the countervailing interests substantially outweigh. Do you really think that's a difference in practice? I thought that we err the other way, that under the Federal Death Penalty Act, we want the countervailing evidence that would affect the sentence to come in more easily than we would with respect to general rules of evidence.
If I could, two points in response to that, Your Honor. First, I actually think it does make a difference because Rule 403, which has the word substantially in it, exists as a backstop to bolster other rules of evidence that already ensure reliability, like the hearsay rule and the best evidence rule, whereas Section 3593C substantially lowers the bar for the admission of evidence in the penalty phase of a capital trial, but nevertheless leaves the district court with some tools to ensure fundamental reliability and ensuring that the evidence is going to be appropriate for the case. And the second point I would make is just what negative effect I think introducing the evidence here would have had. It would have sidetracked the proceedings and consumed a disproportionate amount of it, focusing on Tamerlan, not respondent, and everyone agrees. And again, this is at page 668 of the joint appendix, which is their response to the government's motion to eliminate to seek to exclude this, that this isn't just a comparison game where the jury is invited to decide whether Tamerlan or respondent is a worse person and decide that capital punishment is only appropriate for that person.
Thank you. Thank you, Counsel. Justice
you.
Thomas, anything further? Justice Breyer?
Consider everything Justice Kagan asked. A question. This was their defense. They had no other defense. They agreed he was guilty. Their only claim was, don't give me the death penalty because it's my brother who is the moving force. And isn't there one, I think she's pointed out, a certain difference between evidence that was introduced about the brother, i.e. he shouted at the barber or the butcher, I think was the butcher, etc., and this evidence, which happens to be an affidavit, which says he murdered 3 people, including one of his closest friends, by slitting their throats. Okay? Now, it seems to me there's a difference. Does the government think there's a difference? Well, the government took Tadashev's affidavit and used it to show probable cause to search a car. Now, if the government thinks it stands up enough to show probable cause at least, isn't it enough to get into a death case? When was the last time there was an execution in Massachusetts? I mean, and as far as his knowing about it, the lawyer, what's his name, Kijakazi, all right, that's a complicated name, but it's a simple point. There was evidence in this trial, though introduced before, where he said that is, he was the friend, and the lawyer said, Kijakazi, the friend, says that he did know about it. Nobody denied that he knew about it. All right, so those, I think, were the points that Justice Kagan was trying to make. And unless there's a much tougher rule of mitigating evidence in a death case than there is to show probable cause to search a car, why doesn't this come in?
Well, Your Honor, there were a couple of questions packed in there. Let me respond to the warrant affidavit question and also the Qatarbayev proffer question. On the warrant affidavit question, if you look at page 996 of the joint appendix, which is the warrant affidavit, the agent doesn't endorse any of the details of Tadashev's story. He says that he believes there's probable cause to believe that Tamerlan and Tadashev planned and committed the Waltham crime, but without saying that Tamerlan necessarily played a lead role. And this court made clear in Franks that simply quoting a third party's statements doesn't necessarily endorse them in the context of an affidavit. And moreover, as a more general matter, a warrant affidavit is a very different inquiry into a very different thing. The court has emphasized, for example, in Illinois against Gates, that there's a qualitative difference between probable cause and proof by a preponderance, even by a preponderance of the evidence. And we're just looking at reliability in that context for reliability to investigate further, not reliability to prove anything at trial. On the Qatarbayev proffer, I think there's a very artificial aspect to the way that this inquiry is coming in at the appellate stage. Because at trial, I think the reason they didn't focus on the Qatarbayev proffer, which they mentioned in the course of their discovery motions, but not as a reason to admit this evidence, not as a basis for opposing the government's motion in limine, is because they never wanted Qatarbayev on the stand, probably, because To the extent anything in the Kaderbayev proffer was true, Kaderbayev was offering it to the government, so who knows how it would have come in. And if you look a couple bullet points down on JA 584, you will see that Kaderbayev also offered to testify that 1 month before the bombing, he had a conversation with Respondent, which Respondent admitted that he'd learned how to make bombs and was speaking glowingly of martyrdom.
Justice Alito, anything further? Justice Sotomayor?
I do. Counsel, this is a constitutional right to present mitigating evidence. It seems to me that I'm not sure how we would ever have an abuse of discretion review of solely on a district court's decision not to permit a defendant to put on a defense. It has to be something else, because I don't know of any other situation where you can deny a defendant a constitutional right on a simple weighing. But putting that aside, I'm also unsure what the reliability of this information is about when, although you're saying that they wouldn't have put in the evidence that the defendant knew about this killing, there were multiple people who they proffer to us now who could have testified to the fact that this defendant knew his brother had committed these killings as jihad, which would have meant the truthfulness of the confidential informant was irrelevant, because it doesn't really matter who took the lead in the killing or even if the brother participated in the killing. The only issue would have been, what did the defendant think? And so I'm not sure whether the relevancy issue that the district court ruled on made any sense to me. But please explain to me how what should be the standard of review, assuming a constitutional right to present mitigating evidence, and assuming, as Justice Kagan showed, this evidence was relevant to how this young brother might have reacted to the entreaties of an older brother who had already committed jihad.
Well, Your Honor, the Court of Appeals expressly found that abuse of discretion review was the appropriate standard of review, and Respondent hasn't taken issue with that in this court. And as to the point about knowledge, if you look at page 976 of the Joint Appendix, you will see that the government's motion in limine said that Respondent had not asserted that he knew about the Waltham crime, and we acknowledged it would be a different story if he had. In response, on page 669 of the Joint Appendix, he says that the evidence should come in even assuming arguendo he didn't know about it. And that's the basis on which the district court decided to exclude the evidence. At page 650 of the Joint Appendix, district court says, I'm not letting this evidence in because we fundamentally cannot tell what happened. The district court did not understand this to be a question of Respondent's knowledge, and I think that's one reason to review this with some deference to the district court's rulings, because to require an entire new penalty phase in this case, force all the victims to come back and testify and have to reassess the same sentence is, I think,
Mr.
less
Fagan,
reasonable.
Part of the problem is that the district court withheld information, and so the defense attorney could not proffer everything at once because it didn't have full knowledge of what was there. Now that they do, they can show us how pertinent that information was, and B, how it could have dovetailed easily with what they already had.
Well, Your Honor, first of all,
you can't put the cart before the horse here, and the cart before the horse was the denial of discovery.
Well, first of all, Your Honor, I don't think that Respondent is alleging that the government didn't disclose something related to Respondent's own knowledge. Second, to the extent that they want to pursue further discovery, I think it just emphasizes how this is really going to sidetrack the proceedings into investigation of a different crime. And third, that crime is not particularly related to the Boston bombing, in which respondent personally participated, and there was substantial evidence about the roles of the brothers in planning that crime. Some of that evidence was disputed, but I think what is quite clear and what we put into the record is that there was evidence that respondent told a friend he was planning something with Tamerlan. There was evidence that respondent had sent messages and tweets touting jihad. There was evidence that he bought the gun from his drug dealer. There was evidence he went to a firing range to practice something. Excuse me, I meant to say he told a friend he was doing something with Tamerlan, not necessarily planning something with Tamerlan.
Justice Kagan, anything further?
I do. Here are the mitigating factors that the court itself put to the jury. The court was very well aware of, as Justice Breyer said, the only argument that the defendant was making in this case, which was an argument about undue influence, and an argument that although he did it and he was guilty, that he should not get the death penalty because he was unduly influenced by his brother. And so the court put the following to the jury. Here are the mitigating factors. The defendant acted under the influence of his older brother, whether because of the brother's age, size, aggressiveness, domineering personality, traditional authority as the eldest brother, or other reasons. The defendant was particularly susceptible to his older brother's influence. The defendant's brother planned, led, and directed the bombing. The defendant wouldn't have committed the crimes but for his older brother. Now, all of those, that was the entire case. Were those mitigating factors sufficient to give him life in prison rather than the death penalty? And yet the court keeps out evidence that the older brother committed 3 murders in the way that Justice Breyer explained.
Well, Your Honor, I think I've already gone through the way this came into the district court. But the other thing I'd emphasize is I don't think their theory on probative value is particularly strong. I think if this jury heard that respondent was aware or thought that Tamerlan had committed a murderous act of jihad, it would have expected him to be horrified, not to view that as an affirmative reason to not only follow him in jihad, but to take an even more murderous act by planting a bomb at the Boston Marathon.
As your brief says multiple times in the voir dire context, this jury actually produced a very nuanced verdict. It said anything in any as to any acts that the 2 brothers were together, there were mitigating factors, and death was not the appropriate sentence. It was only the acts where the older brother was not on the scene in which death was appropriate. Now, do you think it's possible, and that's all that has to be shown in such a case, that if all of this evidence about these murders were produced, a jury that was obviously sensitive to the issue of the relationship between the 2 brothers and how that relationship affected the defendant's actions, do you think it's possible that that jury would have said, even when Tamerlan was off the scene, the older brother, he continued to exert an enormous influence, because this is a guy who walks into places and murders 3 people?
Your Honor, there was no evidence that Tamerlan physically intimidated respondent into doing anything. It was, in fact, physically separate when he planted his bomb. And as for the influence evidence, as I've just said, I think the jury is much more likely to have found this weighed against respondent, not as a mitigating factor in his favor. And let's bear in mind that this is a jury who heard evidence about the boat manifesto that respondent wrote after he ran over Tamerlan, in which he justified his actions on the basis of jihad and showed how proud he was of them. And that's after he needn't worry about Tamerlan at all. In fact, he thought he was dying.
Thank you, Mr. Fagan.
Justice Alito?
Mr. Fagan, there's really an interesting sort of evidentiary question here, and I like your explanation of the standard that applies. This evidence is inadmissible many times over in a regular trial where we have rules of evidence. But at the mitigation phase of a penalty of a capital case, maybe the rule is anything goes. And if that is the case, well, that's what I want to know. Is it really anything goes? So suppose what we had in this case was quintuple hearsay about something that Tamerlan supposedly did years ago in Russia. One person in Russia told another person in Russia who told another person in Russia down the line that he did certain things. And that is admitted. Then what can you do in response? Can you then introduce evidence to show that it actually didn't happen? Or can you introduce evidence to impeach the credibility of some of these hearsay declarants? How is all this to be handled?
Well, Your Honor, I think those would be options. I think one way to look at this is if you look at, for example, the court's decision in Green against Georgia, Georgia there maintained its hearsay rules in the penalty phase of a capital trial. And it had imposed the hearsay rule, and this court found that it had violated the defendant's Eighth Amendment right in doing so. But before it was able to reach that conclusion, it assured itself that the evidence was reliable. And I think that is at least a minimum floor that even the Eighth Amendment would require, and at some point, some sort of quadruple hearsay hypothetical that presumably requires some translation from the original Russian might well exceed reliability. And here what you had was evidence that nobody who is still alive would have been able to attest to, unlike the other evidence that was heard in this case.
Justice Gorsuch?
Fagan, on the Waltham murders, we have to review the district court's decision, maybe for abuse of discretion, maybe for something else. And he had to weigh, though, in his mind, on the one hand, the relevance, and on the other hand, the potential for confusion under the statute. And if you could just, putting aside all the hypotheticals, actually give me the government's best argument on why it wasn't relevant, on the one hand, and why it would have caused confusion on the other.
Certainly, Justice Gorsuch. I think there are, now it has boiled down to a couple of theories of relevance. One, and I'll try and be as succinct as I can. One is that it made it more likely that Tamerlan planned the crime. And as I said earlier, and I'm happy to expand on this if you want me to.
I understand their theory. I just want to know your best arguments on why it wasn't that relevant and why it would have caused confusion. Those are the two things you'd have to show.
I think our theory on why it wasn't relevant necessarily responds to their theories of why it was, which is why I'm identifying that.
Let's spot them that. Just as succinctly as you can.
So we don't think even if Tamerlan had participated in this separate crime, that, assuming we had some reliable evidence of that it really shows that he is more likely to have planned this different crime. And as for influence, it really doesn't show any physical influence because, of course, Tadashev opted out. And I don't think shows psychological influence because in order to conclude that, the jury would have to infer that Tamerlan was actually involved, that he did so as an act of jihad, which is not what Tadashev said, that respondent knew about it, the respondent viewed that as essentially a plus factor for following Tamerlan, not as a significant detractor, finding out that his brother is a jihadist murderer, and that would lead him to take his own deliberate acts, of which there were many, physically separate acts, in carrying out the Boston Marathon. As to confusion, I think unreliability of evidence is itself part baked into the confusion inquiry, and I think the jury this would have consumed a disproportionate amount of the penalty phase proceeding focusing on Tamerlan, and it's supposed to be a proceeding that focuses on the individual culpability and history of this particular defendant. And I think it really would invite precisely the kind of comparison game that everyone agrees would be inappropriate. The jury was supposed to be focused on respondent, not on something Tamerlan might have done 2 years earlier that was a quite different crime.
Thank you.
Justice Kavanaugh?
Mr. Fagan, at the beginning of this entire line of questioning, you were asked to assume away something, and I'm confused because you were asked to assume away what I think was the district court's reasoning here, because the district court said, and I'm quoting, there was, quote, insufficient evidence to describe what participation Tamerlan may have had in those events, end quote, and, quote, it is as plausible that Tudashev was the bad guy and Tamerlan was the minor actor. There's just no way of telling who played what role if they played roles, end quote. Now, what do we review that analysis for abuse of discretion, correct?
I agree, Your Honor, and I would just emphasize to the extent we're looking at something different now, they've suggested in their brief that maybe they wanted to produce a more streamlined version of the evidence where they just introduced knowledge and the fact that Tamerlan was involved in some way. That itself is not what the district court was considering either.
The district court here was presented with this theory, and the district court said, we don't know what happened. There's been insufficient evidence of who did what, and therefore the theory that Tamerlan was the lead player in that is entirely unreliable because we don't know, and Tudashev had all the motive in the world to point the finger at the dead guy to say that he was the ringleader of slitting the throats of the 3 drug dealers, right?
That's exactly right, Your Honor. And one other thing I'd emphasize is this wasn't even any sort of final confession from Tudashev. This was basically interrupted midstream when Tudashev, after having talked to the officers, went back into, I believe it was his kitchen, got a pole and tried to attack them, and that's why Tudashev was killed. So I think it's just inherently unreliable midpoint statement from someone who was at least clearly somewhat unhinged and had every reason to pin this on the person who had committed the Boston Marathon bombing along with his brother, the respondent here.
Right. So that's the district court's theory. And then your answers to the line of question were, even assuming that Tamerlan did play the lead role, which we don't have evidence of, the district court concluded. Even assuming that, that still gets into the comparison game that you said the district court could conclude that's not the right role, the right analysis for the jury to take in a case like this.
That's correct, Your Honor.
But I just want to make sure the premise, the premise was assumed away.
The premise was assumed away because that's the role of the jury.
Well, I think it's important to discuss the district court's reasoning. And the district court said, we don't know what happened. And the district court, maybe to answer Justice Kagan's question, does the district court have a gatekeeping role here or not? And maybe that's Justice Alito's question, too.
Well, just to be clear on I think the couple of points you've raised, I don't concede the premise. I agree with the way Your Honor, Justice Kavanaugh has analyzed it. And I also do believe, as I was discussing most in depth probably with Justice Alito and a little bit with the Chief Justice with respect to the statutory requirements in 3593C, the district court does have a very important gatekeeping role here, and I don't really think that's disputed. It's not really an anything goes regime, even in the penalty phase of a capital trial. It is a much, much lower evidentiary standard, everyone agrees, and the Eighth Amendment requires. But it's not anything goes, and the district court reasonably exercises discretion here to keep out inherently unreliable evidence that wasn't especially probative and had a substantial risk of confusing the jurors, as I was just explaining to Justice Gorsuch.
Justice Barrett, anything further?
Mr. Fagan, I'm wondering what the government's end game is here. So the government has declared a moratorium on executions, but you're here defending his death sentences. And if you win, presumably that means that he is relegated to living under threat of a death sentence that the government doesn't plan to carry out. So I'm just having trouble following the point.
Well, Your Honor, the administration continues to believe the jury imposed a sound verdict and that the Court of Appeals was wrong to upset that verdict. If the verdict were to be reinstated eventually, which will require some further proceedings on remand, There'd then be a round of collateral review, some time for reviewing any clemency petitions. Within that time, the Attorney General presumably can review the matters that are currently under review, such as the current execution protocol. And what we are asking here is that the sound judgment of 12 of respondents' peers that he warrants capital punishment for his personal acts in murdering and maiming scores of innocents, and along with his brother, hundreds of innocents at the finish line of the Boston Marathon should be respected.
Thank you.
Ms. Anders?
Mr. Chief Justice, and may it please the Court, under the Constitution, a death sentence is lawful only if it reflects a reliable and reasoned moral judgment to the offense and the defendant's culpability. That bedrock principle was violated in two ways here. First, the district court violated the First Circuit's longstanding voir dire supervisory rule by refusing to learn whether jurors had been exposed to inadmissible and inflammatory publicity that could prejudice their consideration of the death penalty. Second, and more fundamentally, the district court violated the Eighth Amendment by categorically excluding evidence that Tamerlan robbed and murdered 3 people as an act of jihad. That evidence was central to the mitigation case. The defense's entire argument was that Dzhokhar was less culpable because Tamerlan indoctrinated him and then led the bombings. Tamerlan's commission of the murder supplied the key indoctrinating event by demonstrating to Dzhokhar that Tamerlan had irrevocably committed himself to violent jihad. That would have had a profound effect on Dzhokhar, who was already enthralled to his brother and therefore would have felt intense pressure to follow Tamerlan's chosen path and to accept extremist violence as justified. And Tamerlan's prior experience carrying out violent jihad made him more likely to have led the bombings. The evidence's exclusion distorted the penalty phase here by enabling the government to present a deeply misleading account of the key issues of influence and leadership. The government argued that Tamerlan was merely bossy. The Waltham evidence showed that wasn't true. The government argued that Tamerlan did no more than send Dzhokhar a few extremist articles. The Waltham evidence showed that wasn't true. The government argued that the brothers were equal partners because Tamerlan had not succeeded in jihad until Dzhokhar joined him. The Waltham evidence showed that wasn't true either. But the defense couldn't make any of those points. A sentencing proceeding where the defense is not permitted to make its fundamental mitigation argument and to rebut the government's aggravation arguments cannot result in a reliable and constitutional death sentence. Now, I'd just like to start where the Court left off with my friend Mr. Fagan, with the government's acknowledgement that this evidence should have come in if Dzhokhar knew about it and if there was evidence that Tamerlan did it. I think that's exactly right. But the key point here is that the test for relevance is the permissible inferences that the jury can draw from this evidence. And so I think the district court committed legal error here by saying that the evidence lacked any probative value at all, and I don't understand the government to defend that position. I think the far stronger inference here from the evidence was that, in fact, Tamerlan had a significant role in these murders. We know that because not only did Tadashev say that, but there's ample corroborating evidence, which we've gone through in our brief, but that starts with Dzhokhar's own statement to his friend that Tamerlan committed these murders and committed them as an act of jihad. He would not have said that. This has been a minor role. We know that Tamerlan was the one to review just a few weeks before the murders the extremist teachings of Anwar al-Awlaki advocating robbing nonbelievers as a form of jihad. That provided the extremist motivation for this offense. We know that Tamerlan was the one who knew Brendan Mess, the primary victim here. There was no evidence that Tadashev did. And, of course, Tamerlan's involvement is corroborated by computer search history, which shows that either Tamerlan or his wife, within a few days of the murders, searched for Tamerlan's name in connection with the murders. I think there's ample corroborating evidence here. The far more likely inference, the far more plausible inference for a juror to draw would be that Tamerlan was involved in these crimes, that he played a significant role, and that Dzhokhar knew about that. We know that from Dzhokhar's own statement.
Can a trial judge at the penalty phase of a capital trial ever exclude mitigating evidence that meets the very low standard of relevance on the ground that it is highly unreliable?
Yes, I believe the Eighth Amendment would permit a district court to do that. I think the way the framework works, I think, is that once evidence is relevant and reliable, then the Eighth Amendment constrains the district court's discretion to exclude it on other grounds.
So the judge can make a determination of reliability.
Absolutely. And the test for reliability is minimal indicia of reliability. That's what all of the lower courts have used in determining whether evidence should come in a capital sentencing, minimal indicia of reliability. And I think whether evidence satisfies that is a mixed question of law and fact. I think it turns on whether the evidence has corroboration or other indicia of reliability. And I think here the district court committed legal error because the corroborating evidence the government has not disputed. Right? These other evidence that we talk about in our brief, the government has not disputed the reliability of it.
All right, but where the minimum evidence of reliability, minimum standard of reliability is met, and what is at issue is another crime, another event, different from the one that's on trial. To what degree can the prosecution then respond by introducing evidence that disputes the version of the other event that is proffered by the defense? And to what degree can the prosecution respond by impeaching the reliability of the hearsay declarants who provide the mitigating evidence? In other words, at a trial, you don't have these mini trials. If a person's on trial for murder X, you don't have a trial about murder Y and murder Z. But to what degree can a trial judge at the penalty phase say, we're not going to do this, because what would happen then is another trial within this trial about what happened at Waltham?
Well, I guess I would push back against Your Honor's point that this sort of evidence of another crime never comes in, and I think that will enable me to answer the rest of your question. So I think it actually unadjudicated crimes evidence is a staple of capital sentencing proceedings. It often comes in aggravation. The prosecution offers it.
I was talking about a trial where there are rules of evidence. This stuff doesn't come in. And my question is, to what degree, if any, do the considerations that keep it out at a trial where there are rules of evidence also apply in a diminished form at the penalty phase? Or is it the case that if the defense puts in anything that's relevant and it has minimum evidence of reliability, then you're off to the races and you have a mini trial about this other event? Or is it one-sided? The defense gets to put in this minimally reliable evidence, but the prosecution cannot respond.
Well, two points in response to that. I think the first would be, if we were looking at this under the rules of evidence, so at trial, actually there would be no basis for categorical exclusion on reliability grounds. Todashev's statement would be treated as a statement against interest under the federal rules of evidence, 804B, and at least those statements in which Todashev implicated both himself and Tamerlan would come in under this court's decision in Williamson. So I think even looking at this under the rules of evidence, there would be no basis for categorical exclusion. I think that just points up the legal error in the district court's ruling here. And I would say, with respect to capital sentencing, what this court has said over and over again, including in Gregg, is that more evidence should come in at the capital sentencing phase, not less. And that's because we think the jury will make a more reliable sentencing determination if the jury gets to see the evidence. Fourth Circuit said this in Runyon, cited in our brief, that the jury, not the judge, is the primary arbiter of reliability at the sentencing phase.
Ms. Anderson, can I ask you a question that follows up on that? So the Federal Death Penalty Act, the first sentence says the defendant may present any information relevant to a mitigating factor. That's consistent with our Eighth Amendment jurisprudence. But it goes on to say information may be excluded if its probative value is outweighed by the danger of creating unfair prejudice, confusing the issues, or misleading the jury. So I want to know if reliability is the same as that. And just because something would be admitted under the federal rules of evidence as a statement against interest, or I guess put differently, the hearsay rules wouldn't keep it out, doesn't mean that the district court wouldn't have discretion under 403, under a very similar standard as this, to keep it out. So I think another way to think about Justice Alito's question is this part of the Federal Death Penalty Act inconsistent with the Eighth Amendment? Or do you think that that sentence in the Federal Death Penalty Act is a legitimate ground for excluding evidence?
I don't think the two are inconsistent, and I'll answer that directly. But first, let me say that I think the way to think about reliability here is that the district court committed legal error by finding that the corroborating evidence here didn't rise to the level of the minimal indicia of reliability, the standard that applies. And I do think the fact how this would be treated under the hearsay rules actually is quite probative here, because, of course, the hearsay rules are designed to reflect what we think of as more reliable statements that should come in.
But regardless of reliability and reliability under the hearsay rules, we still have 403, and in fact, you know, the court was weighing, the risk of prejudice, unfair prejudice, against its probative value, which the district court thought was nil. So put aside reliability for a minute, and I want to know, because this seems to be, the gravamen of Justice Alito's question and of what the district court did. It was saying this would spin off into a mini-trial. Its probative value was low. It would confuse the jury, and it wouldn't add much. Are those legitimate grounds for excluding the evidence under the Federal Death Penalty Act and the Eighth Amendment?
Well, those are obviously the grounds that the Federal Death Penalty Act allows district courts to consider, but let me just sort of break down how I think that works here. So with respect to confusion, I think that ordinarily one would review a district court's conclusion that evidence might be confusing deferentially, but I don't think that's the case here, and the reason for that is that the court first said this evidence has no probative value. It is completely irrelevant. So I think the confusion ruling that the district court reached is bound up, follows directly from its relevance ruling, and so you can't separate the two. And because of that, the district court never did any weighing here under the FDPA. It said the evidence is completely irrelevant. That's all it really needed to find, right? There was no weighing of countervailing considerations.
I think there are two different theories here, though, for why it should come in that you have, and correct me if I'm wrong. One, emphasized more at trial, was that Tamerlan had played a lead role in the Waltham murders, and therefore that was relevant to show a lead role here. And the district court said, as I quoted earlier, there was insufficient evidence to show or establish or be probative of that theory at all. A second theory, which I think you're emphasizing more here, is the mere fact that Tamerlan committed another murder is itself relevant. So suppose Tamerlan had committed the Waltham murders by himself and it was undisputed. Would that be something that has to come in the death penalty trial here, or the penalty phase of his brother?
I think it absolutely would be something that would.
And explain the relevance there, where the defendant is saying that the defendant committed these murders and named these people, but my co-defendant is a worse person because he previously committed some other murders. Is that the theory, or explain to me the theory, because that's not registering completely with me.
Sure. So that's not the theory. The theory is that Tamerlan influenced Dzhokhar, Tamerlan indoctrinated Dzhokhar, and Dzhokhar radicalized because of Tamerlan, and Tamerlan was more likely to have led the bombings. I think Tamerlan's commission of a previous jihadist murder was directly relevant to that theory, and that's so for a couple reasons. I think the first is that this was the key indoctrinating event, right? Everything else in the admitted evidence was just talk. It's just that Tamerlan sent Dzhokhar a few articles. This was the event by which Tamerlan demonstrated his absolute commitment to violent jihad. We already know that Tamerlan was enthralled that Dzhokhar was enthralled to Tamerlan, that he was occupied a subordinate position in the family hierarchy. In light of that, he would have felt tremendous pressure to accept Tamerlan's violence as justified. And I think we know that that was really important here, that the murder was the key indoctrinating event because of the arguments that the government was able to make in the absence of this evidence. So as I said, the whole dispute here between the government and the defense was, how did Dzhokhar radicalize? Why did he radicalize? The admitted evidence, as I said, was simply that in terms of actual persuasion, the only actual persuasion was that Tamerlan had sent Dzhokhar a few articles.
Well, I thought the evidence on how he radicalized was that he read Inspire, Al-Qaeda's magazine. He read Anwar al-Awlaki's messages, and he became influenced by those and decided that he wanted to wage war against America.
Right, and all of those articles were given to him by Tamerlan. And so what the government was able to argue was, look, Dzhokhar must have radicalized on his own by reading those articles, because nothing about the fact that Tamerlan gave him articles would exert any kind of influence. So in other words, if you're a younger brother under your older brother's sway, you won't feel any particular need to accede to persuasion. If the form of persuasion takes is a few emails that say, hey, here's an article I thought you might be interested in, the Waltham murders would have proven that that's not all that was going on between the brothers. Tamerlan, at the time that Dzhokhar was attending freshman orientation, Tamerlan was committing jihadist murder. He demonstrated through that that he was absolutely committed, that he was irrevocably committed to the point of murdering his friend, right? And at that point, Dzhokhar would have faced a choice. Does he follow? Does he not? We already know that he was under Tamerlan's sway, and so there would have been tremendous pressure there. That's what the jury could have found. And with respect to leadership, I also think that the murder is incredibly probative here. So the admitted evidence showed that Tamerlan was older, that he occupied a superior position in the hierarchy, but there was nothing in the admitted evidence that showed that Tamerlan had the ability to carry out a jihadist offense, that he had done it before, and that he had the experience to do that. So the government was able to argue, look, Tamerlan's never actually succeeded in anything. He's ineffectual. He's merely bossy. And so, whatever you think about his being older and having influence on his brother, that doesn't matter. The brothers must have been equal partners because Dzhokhar was not able to go into action. That's at page 873 of the J8. He was not able to go into action until Dzhokhar joined him. That suggests...
Just to follow up on this question from Justice Kavanaugh, as I understood it, your primary theory below on the relevance of this evidence, Waltham, was to show that the brother had leadership, had taken leadership of other crimes before, similar crimes. Is that right?
I think we made all of these arguments below. I think that's one thing about this evidence. It supports a variety of inferences. So if you look at JA 60...
That certainly seems to be what the district court understood your argument to be, though. Would you agree?
I think the district court concluded, as we've been talking about, that there was no way to tell, in its view, who did what in the apartment. But
okay, so let's deal with let's pursue that then. If the district court's theory was, the district court understood your theory to be that this evidence showed the brother's leadership capacities and roles, and if the district court found that based on the evidence before it, there's really no way to know who took the leadership role in the Waltham murders, because the evidence is gone now. The witnesses are unavailable. What do we do with that?
Well, I think that is error, too, because if you look at what the defense said to the district court, it was a broader theory than that. So,
but let's just deal with that theory. Let's assume that's the theory that again, maybe I'm unfairly asking you to put things aside, but with respect to that theory, what's wrong with the district court's conclusion?
I think there are several things. It's not a basis for categorical exclusion. I do think the first point would be that
again, counsel, though, you're fighting the hypothetical, and I understand that, but I don't like a lot of hypotheticals either sometimes. But if the theory was it shows leadership because he's done leadership in the past, and if the evidence is impossible to determine who led the Waltham murders, then what?
Well, again, I think that would still be error, because even if that's the theory, the district court, there was corroborating evidence, I think, that suggested a leadership role here, and both parties pointed out to the district court that you could analogize to the federal rules of evidence, that you might have a situation in which some things come in but some things don't, and so I think that's why the court erred in categorically excluding this. And I think the corroborating evidence that would have suggested a leadership role here, again, Tamerlan's the one who's steeped in jihadist materials. Tamerlan's the one who knows Brendan Mess. Tadashev says, and this is something that the government credited in the search warrant, that Tamerlan was the one who came up with this. Tamerlan's the one he's the only one who knew the victims.
Well, and Tadashev also was in the course of writing his confession to the crime when he attempted to overcome the law enforcement officers.
That's correct, and that's something certainly the government could have pointed out. But again, I think the test for reliability here is this statement corroborated by other evidence? We think there's ample evidence to corroborate it, and that's before we even get to the search warrant, in which the government itself credited at least some of Tadashev's statements, said these are appropriately accepted as true for Fourth Amendment purposes. That is what the government represented in that warrant. And so we think that ought to be compelling evidence in thinking about reliability, that this was certainly reliable enough to go to the jury, because of course it is the jury, again, that is the ultimate arbiter of reliability at the penalty phase.
So what is your response precisely to the claim, and the government makes it? Look, thinks the judge, if I let in this Tadashev affidavit, there are about 7 issues here about whether I'm going to have a trial. I mean, about whether Tadashev is lying, about what the defendant actually knew, about. Now, your response to that, this trial's already gone on a long time, It'll go on for another year. Now, what's your response to that?
So I have several responses to that. The first is that, as we've said in our brief, that not all of the Tadashev statements would have had to be admitted. We don't think that the jury needed to reach definitive conclusions about who slit the throats in order to determine that Tadashev played a major role here and did so for jihadist purposes. So the court would have had discretion to limit the presentation of evidence in that respect. The second thing I would say is that just because evidence is contested by the government doesn't make it unreliable. As I mentioned before, unadjudicated crimes evidence comes in all the time and the defendant contests it. And that is never thought to be a mini-trial in any other circumstance. And certainly in this case, there were other forms of hearsay. There were other FBI reports that came in where witnesses described to the FBI their interactions with Tamerlan, and nobody thought that the jury was going to get all tied up and it was going to take years to figure out exactly what Tamerlan said, whether he'd said what the witnesses said he said. Everybody understood that what could happen was that the jury would evaluate those reports in conjunction with an instruction from the judge about how to evaluate them, the fact that they're hearsay, and then any corroborating evidence. That's what juries do. And then the final thing I would say is that although the government has said that there would be a, extensive mini-trial here, it has never really said what that evidence would be. I mean, as far as we can tell, this would more naturally be attorney argument. This would be, just as it actually happened at trial, the government would get up in its opening and closings and tell the jury what it thought the jury should take from this information. That would not be a mini-trial. That's just a little bit more in an opening or closing.
Ms. Anderson, in your brief, I thought that you were arguing that there is no real balancing test under this rule, under 3593, with respect to mitigation, that it has to be, as I think some of your amici argue, that the balancing has to be with respect to aggravating evidence, that there is a different standard of applicable to mitigating evidence. It sort of doesn't make any sense to have a pure 50-50 balancing test with respect to mitigation because it's a constitutional right.
I think certainly in the case of mitigating evidence, the Eighth Amendment does come into play and imposes an independent constraint on the district court's discretion. And the way I think that works is that once evidence is relevant and reliable, the Eighth Amendment creates a strong presumption that the evidence should be admitted in some form. And so I think it would take some extraordinary concern on the other side to justify categorically excluding evidence, especially when there are case presentation ways, there are narrower ways for a district court to address whatever case presentation concerns it has. And I think in this case, none of the countervailing concerns the government has identified come close to satisfying that high standard to justify categorical exclusion. I've just been talking about confusion. I think, again, the government's confusion arguments I don't think provide on their own terms a basis for categorical exclusion here. And the government would not have to do anything more, I think, than make these arguments. And we've also talked about reliability. I think, again, the statements here were amply corroborated by analogy to the federal rules. I think there was ample reason that they should come in before we even talk about the search warrant. And I just want to make clear something here about the extent to which this exclusion distorted the entire penalty proceeding. And I think the way that this unfolded is particularly important. So the government moved in limine before the penalty phase began to have this information categorically excluded. That freed the government to tell the jury in its opening and then again in its closing that influence was the quote-unquote centerpiece of the defense's case and that the government and that the defense had presented no evidence. That's another quote from 816 of influence. Then, throughout the penalty phase and in its rebuttal, the government was able to argue that Tamerlan is merely bossy, that he merely sent Dzhokhar a few articles, that's all the influence that happened, that Tamerlan couldn't go into action until Dzhokhar joined him. The Waltham evidence would have changed the terms of the debate. The government could not have made those arguments. If it had, the defense would have said, Tamerlan is not just bossy, he's violent. He's already committed violent jihad. Dzhokhar knows about it. There's no question that would have a profound...
Well, it would change assuming it would change the terms of the debate, it would focus debate on something that the district court determined really just couldn't be resolved. There were no witnesses available. They were both dead. And he concluded that would require, I don't know if he used the term or not, but a mini-trial, certainly a detour into something that at the end of the day there was no basis for resolving. It isn't a question of who do you believe? They're both dead, and they're not there, and the determination is whether that was an abuse of discretion.
I think the district court committed legal error in making that conclusion because, again, it's a question of sort of minimal indicia of reliability. And so I think the jury would have evaluated this evidence the way it would evaluate any hearsay evidence. It would put the statement next to the corroborating evidence, and it would decide what it thought. And I think here we're not just talking about Tadashev's statement. I think that's critical. We're talking about corroborating documentary evidence, Dzhokhar's own statement that Tamerlan did this. The jury could have evaluated all of that. I don't think it would have taken a mini trial because, again, we're talking about a fairly limited universe of evidence here that could have been presented quickly. And again, this goes to a central aspect of the penalty phase. I mean, this was the mitigation case, so I don't think this could be an improper mini trial here. It's the trial, right? This is the issue. As to whether Dzhokhar is going to get the death sentence or not. It's whether he was indoctrinated at Tamerlan's instigation and whether Tamerlan was more likely to lead. That's the only argument that the defense has. And so I think the idea that it would be an improper mini trial to put on some hearsay evidence when many other pieces of hearsay evidence came in throughout this penalty phase from both sides and have the jury evaluate that in the context of corroborating evidence, I just don't think that can be a mini trial.
Just to be clear, what is your argument about the standard under the federal death penalty statute? Do you argue that the balancing applies only to the aggravating evidence and not the mitigating evidence? If it applies to the mitigating evidence, do you argue that it's inconsistent with the Eighth Amendment?
No, I think the way that this works is that the FDPA sets a sort of very broad standard, and what the courts of appeals have recognized is that constitutional prohibitions on admitting aggravating evidence, and then, of course, the Eighth Amendment concerns about admitting evidence, those also operate on the district court's discretion. And so I think under the Eighth Amendment, which would control in the case of mitigating evidence, the court has discretion, but once evidence is relevant and reliable, that discretion is limited. The Eighth Amendment creates a strong presumption that the evidence should come in some form, and I think that principle comes from both Skipper versus South Carolina and Green versus Georgia.
Well, I'm not sure I really understand your answer. The statute says that the evidence may be excluded if the probative value is outweighed by the danger of creating unfair prejudice, confusing the issues, or misleading the jury. Is that the standard for the exclusion of mitigating evidence?
I think the Eighth Amendment will control when the mitigating evidence is relevant and reliable, and it will limit the discretion further. I think that the courts of appeals have said the exact same thing in the context of the Fifth and Sixth Amendments.
I don't understand. Either that's the test or the Eighth Amendment supersedes it to some degree. I gather it's the latter. You think the Eighth Amendment supersedes this to some degree. This is to some degree unconstitutional.
I think the Eighth Amendment, yes, provides a superseding limit on discretion just the way that other amendments provide a superseding limit on discretion when we're talking about admitting aggravating evidence. That's what the Second Circuit said in Fell. It's what many of the other courts of appeals have concluded, that when there is a constitutional concern, the court, of course, has to exercise. But
just to get a straight answer to Justice Alito's question, so you are saying that last phrase when we're talking about mitigating evidence is inapplicable or inconsistent with the Eighth Amendment, because once evidence passes the threshold of reliable and probative, the court can't consider prejudice, confusion of the issues, et cetera, as a reason for excluding it.
No, to be very clear, it can consider those issues. I just think that the Eighth Amendment creates a strong presumption that those issues would have to be extraordinarily weighty before they could justify.
But it doesn't even say substantially outweigh like 403 does. It just says outweighs.
Right, but I think the Eighth Amendment imposes a constraint here, and again, this comes from Skipper versus South Carolina, that where the evidence is relevant and reliable, countervailing concerns would have to be extraordinary. They would have to be extremely weighty.
So the answer then to Justice Alito's question would be that it's unconstitutional when applied to mitigating evidence, at least to some degree, under the Eighth Amendment.
I think you could think about it that way, but I don't think that's how the courts of appeals have thought about it that way.
But that's your position, right? Because the last sentence just says outweighs, and it tells the district court, unless it's only applicable, as Justice Sotomayor suggested, to aggravating evidence.
Right. I think the Eighth Amendment, the discretion under the Eighth Amendment is in some circumstances more limited than the discretion under the FDPA, yes. And the courts have said the same thing with respect to aggravating evidence.
Did you make this argument below that the Federal Death Penalty Act is unconstitutional? It strikes me as kind of a new thing here today.
No, again, I don't think we have to establish that the FDPA is unconstitutional because the Eighth Amendment just provides another constraint on discretion. That's what we said below, that this was both an FDPA claim and it was an Eighth Amendment claim. I think another way to think about this actually is that, in some ways you don't have to get to it here, because what the district court actually said here was this evidence is completely irrelevant and therefore confusing. So the district court never got to any weighing under the FDPA. So we're in a situation in which there really isn't any discretionary determination to review under the FDPA. And just make one more point with respect to something my friend on the other side said, which was the point that this evidence somehow is double-edged. I just don't think, again, that would be a basis for exclusion here. This is powerful mitigating evidence that showed that Dzhokhar was indoctrinated at the instigation of his brother. I think we know that influence and leadership are incredibly powerful mitigating concerns because of what happened in the D.C. sniper case. We know that that was a situation similar to here, where Lee Malva was a teenager at the time he committed the offense, and he was radicalized at the behest of an older man. He believed those crimes were religiously justified all the way through, and yet the evidence of influence that he radicalized at someone else's instigation was enough to warrant a life sentence. I think that is what could have happened to Dzhokhar here if this evidence had been permitted in.
Ms. Anders, you're welcome to take more time if you'd like.
If the court has further questions.
Justice Thomas?
If the government had testimony that was almost exactly what you have, but it occurred in, let's say, Roxbury or Dorchester, and respondent was shown to be the leader there, and the government attempted to introduce that as an aggravator, what would your response be to the government? What would your reaction be to that?
I think it would be very difficult to keep that evidence out for exactly the same reasons, that it would be relevant. And of course, the government often offers evidence just like this, right? Or evidence just like Your Honor is positing, evidence where we think that the defendant has committed some other offense, and there's no way to know with 100% forensic certainty what actually happened. I think this
even though the individual who disclosed it has done exactly what this individual did to the FBI, where he's dead now, but and he's dead because he attempted to attack them. I mean, you would think that would still be admissible.
I think certainly the defense could make those arguments, but yes, I think it would be difficult to keep it out for exactly the same reasons, that the jury is the primary arbiter of reliability here, and so the jury ought to hear that evidence. I think that's what the lower courts have generally held in the case of aggravating evidence of unadjudicated crimes.
And I'd like to, excuse me, ask you one question about the jury selection. You said that this supervisory rule had been in place for quite some time, and you suggest, at least I got the sense that you thought it was regularly applied. How often has it been applied?
Well, as far as we can tell, the district courts for 50 years have consistently complied with this rule. So when one or the other party has requested content questioning, the district courts have done it. So it has not come up as an appellate issue very much, from what we can tell.
Is it published any place other than the one opinion?
Yes, the First Circuit has relied on the patriarchal rule a couple of times. It has said that it is the standards of the circuit, the standards of this circuit in a case called Medina, and more recently it has reviewed voir dire against patriarcha and has concluded that the voir dire complied with patriarcha. So yes, this is something that the First Circuit has applied when it has come to it. But as I say, as far as we can tell, generally the district courts are they're complying with this rule, and I think that just reflects this is a routine question that's often asked. It helps the government as well.
We've generally given the district courts quite a bit of discretion at the jury selection stage. Could the Court of Appeals displace that with a list of mandatory questions that it thinks should be asked in every single complicated or widely publicized case?
Well, I think that would present a closer question because the district court does have discretion. But I think what the district court did here was well within this court's precedents, both in the racial bias context in Rosales-Lopez and also the Moomin decision, where the court said that this kind of questioning is helpful. And I guess I would just make the point that this isn't a wooden rule. This is a rule that the district court has discretion to decide applies at the outset, and then it has discretion to decide how to apply it.
So how do we know how far the Court of Appeals could go with displacing discretion? I mean, how do you know whether a rule is too detailed or there are too many rules or too wooden?
Well, I suspect it would turn on something of a functional analysis. I think the reason for district court discretion is that generally we think of the district court as better placed, to decide what questions to ask in the moment. What the court said in Rosales-Lopez is that there's nothing inconsistent about that recognition and having some narrow rules where eliciting more information is both a good idea and also serves judicial integrity. So I do think there would probably be some point at which we would think that no longer is this serving the purpose it was supposed to serve. But I think we're very far from that here because this again is a very narrow rule that follows directly from Moomin and is within the framework that the court announced in Rosales-Lopez.
Thank you.
Justice Breyer? Justice Alito? Justice Sotomayor? Justice Kagan? Any further? Justice Barrett? Thank you, counsel.
Thank you.
Rebuttal, Mr. Fagan?
Thank you, Mr. Chief Justice. The Court's been quite generous with its time, and I just want to make 3 points. One, and they're all focused on Waltham because I think that's really the only thing that respondents focused on at this point. One is that my friend on the other side analogized this Todashev's statement to a statement against interest. I don't think it would come in under that rule because his own admission to involvement in the crime would be, but his attempt to pin it all on the dead man Tamerlan, the Boston bombing suspect, would not be. Second, as far as admissibility, they've really focused on this indoctrination theory, and I think that is really not especially probative of anything that is mitigating here. I mean, essentially what they'd be arguing to the jury is, yeah, Tamerlan sent all this jihadist literature, but what really got me into the jihadist literature was learning that at the end of the road in jihad is committing murder. And moreover, I want to amp that up by committing murder at the finish line of the Boston Marathon. I don't think that is particularly helpful or particularly probative as far as mitigation goes. And I think that dovetails with the third point I want to make here, which is it's in some ways easy to view all this from an appellate remove, which is what we're doing here. But the easiest way to resolve this case is simply on harmless error principles and think about what the jury actually heard. I don't think this comes through as much in the briefs as if the court takes a little bit of time. It'll only take a little bit of time to review some of the video evidence that's included in the joint appendix. I'd particularly recommend Exhibits 22, 23, and 1304C. And what those exhibits show, I've already gone through some of the evidence about respondent being involved in the planning of the offense. But what those exhibits are going to show is respondent physically separating from his brother near the finish line of the Boston Marathon, positioning himself behind a group of children, putting down his backpack. We can't really quite see that part, but rest assured that he did it. Putting down his backpack, contemplating for about 3 minutes, taking out his phone and calling his brother, after which the first bomb goes off. So Tamerlan's clearly waiting for a signal from respondent. Respondent then, while everyone in the Forum restaurant patio is panicking and wondering what just happened, actually they don't even know enough to panic yet, respondent walks off at a normal rate of speed. It's not a very wide-angle camera on the Forum patio, so he barely gets off screen before 20 seconds later the second bomb explodes, killing and maiming people that were seconds ago, wondering what had just happened. If that's not someone who set off the bomb himself, or at least knew exactly when it was going to go off and what its blast radius was going to be, I don't know what is. Then after the bombing, respondent who lives 60 miles away from Tamerlan joins up with Tamerlan for a daring escape in which they kill a police officer in cold blood in a failed attempt to steal his firearm. They carjack and kidnap an innocent graduate student, and then they engage in a violent shootout with police officers in Watertown, during which respondent is lighting pipe bombs and throwing them at the police. Then, when Tamerlan rushes the police, respondent gets back in the stolen SUV, and instead of just driving away, he does a three-point turn. He comes back at the confrontation. The police officers manage to get out of the way, but he runs over Tamerlan. He then destroys his phone so that he can't be located and hides out in someone's backyard in a boat where he writes a manifesto justifying his jihadist acts. That's all the evidence that the jury heard that was admissible evidence that came in this case. And the jury's nuanced verdict in this case was based on that evidence, not anything about pretrial publicity or anything about Waltham. Thank you.
Thank you, counsel. The case is submitted. We'll hear argument next in Case 2480, Babcock versus Kijakazi. Mr. Katyal?
Thank you, Mr. Chief Justice, and may it please the Court. I'd like to begin with the statutory text. Section 415A7A is found at Petition Appendix page 69A, and it excludes from the Windfall elimination provision, quote, a payment based wholly on service as a member of a uniformed service as defined in Section 410M. David Babcock, who served as a dual-status technician in the National Guard for 33 years, qualifies. Indeed, 32 U.S.C. 709 requires technicians like him to literally, quote, wear the uniform of the armed services, be a member of the National Guard, and hold the military grade specified by the Secretary. And Babcock did. He wore the U.S. Army uniform day in, day out, teaching people how to fly Black Hawk helicopters and the like. Babcock engaged in service. He was a dual-status tech. He's undoubtedly a member of a uniformed service, Indeed, the Section 410M expressly says National Guard folks qualify. The government says Babcock was a civilian. Even if this were true, it'd be irrelevant. The key statute, 415, doesn't use a civil versus military dividing line. It simply asks, was the service uniformed? The government attempts to say that Babcock's service was not as wholly a member of the uniformed service. But the best reading of the statute, even before one gets to the veterans canon, rejects that. There is no status language in 415. The government would convert the word as into a status test, trying to discern what hat someone was wearing at a given point in time. Congress certainly could have made such a choice, and indeed it has in many other statutes, but it did nothing like that here. So we have three basic arguments. One, the statute doesn't look to civilian status, it looks to uniformed service. Second, even if civilian status mattered, this would meet it. Dual status tech service is irreducibly military. And third, if there's any ambiguity, the veterans canon would suggest reading it in favor of Mr. Babcock.
Counsel, if just a simple factual question, if petitioner was receiving was exclusively uniformed service, then why is he receiving a civilian pension and a military pension?
Yeah, that's just the way the statute works. And Justice Thomas, it's very much like something that's common ground between both the government and us, which is that inactive service members who didn't pay into the system would receive both. That's what Congress certainly had in mind in the uniformed service exception.
That's not exactly. Part of it's civilian and part of it is military. If your argument is right, it would seem that it would be all military. That makes sense if you're talking about NOAA or you're talking about the Coast Guard. It's all it's consistent with what you're saying, that the service was uniformed service as opposed to part civilian, since he's wearing more than one hat. It is a dual position. So part civilian, part military. And I don't understand how you could have that and now argue that it's all military.
Well, we're saying, Your Honor, that it's all uniformed service. That's the language of 410M. And so it does certainly have some civilian overtones. Civilian versus uniformed service are not mutually exclusive categories.
Is there any other service where that's the case?
Well, we do
other than this.
Well, the NOAA and the Public Health Service.
But they're designated by statute,
correct,
right?
Correct.
And petitioner is not.
No, Justice Thomas, that is designated by statute just as much. So the National Guard is enumerated in the Congress specified in the uniformed service exception certain services that were defined as uniformed, and that's 410M. And when you look at 410M and the cross-reference, it says that NOAA and public health services are certainly included, but so too is the National Guard of the United States. Now, Justice Thomas, you're absolutely right. There is no other category besides dual status technicians that fall within our argument about 410M.
But petitioner is not acting as a member of the National Guard of the United States all the time.
So our argument is that he is all the time, and that Congress in 410M didn't draw any distinction. Now, absolutely, Justice Thomas, my friend on the other side, has made that argument before this court for the first time, that there's some distinction between the National Guard of the United States and the National Guard in general. And as I was saying to you in my first answer to you, the problem with that is that it would ultimately, first of all, that's not the way the government administers the statute. At page 24 of their brief, they admit that it covers inactive duty folks. And if there's the National Guard of the United States, and that's the only thing swept up in the uniformed service exception, the problem with that is then Congress didn't reach the one category that was common ground that we both agree was covered by the uniformed service exception. That's why I think this late-breaking theory by the Solicitor General 27 years after the statute has passed, I don't think really works. It also doesn't work because the statutes say that once you're a member of the National Guard, you're automatically concurrently enlisted in the National Guard of the United United States. And here that's really true. As I was saying, Babcock is required, as with all dual status technicians, to wear the uniform, a United States uniform. So he wears the United States Army. It's emblazoned on his uniform when he goes to work every day.
I don't think when they say the uniformed service, they mean does he wear a uniform or not. I mean, I appreciate he wears the uniform because of his National Guard service. But he gets 2 checks, right? 2 checks a month or however often. One is for his National Guard service, I don't know whether it's a weekend a month or however much it is, and then another check for his 9-to-5 civilian job. The former is based wholly on his uniformed service, working in the uniformed service. But the other is based wholly on his civilian job. Now, the one is subject to the exemption from the windfall exception, if that's right. But the other isn't, because it's certainly not based wholly on his service in the National Guard. It's based on his civilian service.
So, Mr. Chief Justice, we do think that the other is one that falls squarely within the uniform service exception. That is, you're absolutely right. The statute doesn't ask, are you literally wearing a uniform at any time? It asks, are you a member of a service that is a uniform service? And then the statute tells us exactly what is a uniform service in Title 42, and it includes the National Guard, in contrast to, as Justice Thomas was asking about, Title 5, which for purposes of other things, like bookkeeping, calls them civilian. So I don't think the fact that they are civilian answers the fundamental question, which is Babcock serving as a member of a uniformed service at the time? Now, my friend on the other side says, well, that's a different hat, because that is the National Guard, the state National Guard. But as I say, if that's the test, then it would mean inactive duty folks who stand very much like Mr. Babcock don't get that wouldn't be able to be eligible for the uniform service exception either, because they're the same. They fall in the same exact category. They're people who didn't pay into the system before 1988. Congress undoubtedly said for those folks, absolutely, they should get it. And the reason for this, and it sounds a little arcane, but I think the reason why this all exists is people like Babcock or others joined federal employment with a certain set of expectations, and one of those expectations was they would get a windfall if they fell within this. Congress later changed that in 1983 and adopted a broad windfall elimination provision, one that sweeps very large. 1.9 million people are encompassed by that. But in 1994, they said, well, if you're serving in uniform, if your service is wholly there, then you should get an exemption, the uniform service exemption. And so that's what it's about. And so it's certainly about inactive service folks who didn't pay into the system, but see their paycheck slashed decades after they started their employment. They don't really remember whether they paid into the system or not. Congress said, we want to get rid of that. And as our reply brief at page 14 says, once Congress decided to get into that question, then it stands to reason that folks like dual status technicians like Mr. Babcock are just like those inactive service folks. They're people who didn't pay into the system, but see their paycheck slashed decades later. And these are people who are truly through and through military, to the extent that that was even the test in terms of the way they perform.
I don't see how you can say through and through military when their job title is dual status. Well, I mean, what are the two statuses?
Well, it's a military and civilian, to be short.
Yeah, sure. But so their pension payments are not based wholly on the military service. They get a pension based on their military service, and that works the way you want the whole thing to work in terms of accepting the application of the windfall exception. But I don't see, or I think how does the other part of it, not the whole thing. I understand you want to look at the whole thing and say the whole thing is based on military service. It seems to me the whole system separates out the two to the extent that they call the position dual.
So two things, Mr. Chief Justice. First, the title is not just dual status tech. It's you can see it at 32 U.S.C. 709B, which is Petition Appendix page 64A, and it's military technician dual status. And then at 10 U.S.C. 10216, it calls them military technicians and military 24 whopping times. So I think Congress has said, to the extent that you even looked at this military civil line, I think they're calling them more military, if anything. Now, the second point is we don't think that the words of the statute have some sort of purity test, that you've got to be all military all the time. You don't have
to be all military all the time, but maybe you do when they say the payment has to be based wholly on service as a member of the uniformed service.
I agree that's one way to read it. I just don't think it's the best way. And so, let me walk you through the way that we understand wholly, which is it's a very severe test, as our reply brief at page 10 says. What it says is that if there's even a drop of money that comes not from uniformed service, then you don't get the exception, the uniformed service exception. So Congress in 1983 passed a broad provision, the Windfall Elimination provision, which says, quote, if any part or whole of the money comes from non-covered service, then you're in the Windfall Elimination provision. That's what they said. That's a sweeping, broad provision that affects 1.9 million Americans each year. And then Congress said, we're going to enact a narrow exception only for those who are wholly in uniformed service, people who basically spent their career doing that. And so the word wholly has a lot of meaning. It's integral to our reading of the statute, because without it, it means that you can have just a little bit of money from uniformed service, and then you're entirely out of this broad windfall elimination provision. So it's not the case that we're not giving wholly work. We're giving it a lot of work. Indeed, it's integral to the way we read the statute. To my friend's reading, and Mr. Chief Justice, I think your reading, suggests that wholly would modify the word service, not payment. And I think that's not what Congress had in mind. Congress certainly has in other statutes focused on the status or something like that, but it hasn't here, and that's why our brief linguistically walks you through that at page 29, saying wholly would have to be two words down in the statute in order for this to apply. And so we think it's we do think it's the best reading of the statute to really to understand this. I think the government itself at page 22 of their brief admits that wholly modifies the word payment, not service. And so when you read the statute, you simply ask whether or not the service is as a member of a uniformed service. And here, when someone like Mr. Babcock or dual status technicians are performing their duties, they're literally having to wear the uniform, having to be in military rank, having to comply with all sorts of fitness requirements that us civilians
what if a private employer said, I'm very patriotic, I really like employing members of the National Guard, and all of these same requirements that you're articulating says, I want you to wear your uniform to work, I want you to maintain a certain rank, I want you to maintain a certain fitness level, but Mr. Babcock is doing the same job that he's doing, teaching pilot flight school, but he's doing it for a private employer. Yep. Would that be service as a member?
It
of
wouldn't.
The National Guard?
So two things, Justice Barrett. First is, of course, if a private employer did anything at this point in time, it's all covered employment. So this case
imagine
really,
not.
Right, I just want to make sure that, focus on, it's impossible for these kinds of hypotheticals to arise. And then second, we definitely don't think that a private employer can somehow supplement and define what is a National Guard duty. Those are enumerated by statute in 709 and 10216.
But why would that matter? Why does it matter if there are two employers rather than one? Is it just the fact that he works for the government?
It's not two employers rather than one. We're just asking, when you ask what is service as a member of a uniformed service, I think that can only be done by someone who is a member of a uniformed service. Now, if the hypothetical is the employer makes those people become, say, National Guard members or something like that.
That is the hypothetical.
Yeah, and then our point would be, in that circumstance, they'd still have they'd have to be performing the duties that National Guard folks do enumerated by statute, not other duties. If they're doing other things, they're just not. They're not service. Their service is not as a member of a uniformed service.
How about if they're delivering food to the National Guard? It's a private company with all of the prerequisites that Justice Barrett said, and they're delivering mess.
I think you look to the way Congress has characterized the duty, if there's any clue, like here there is, to say you want to focus on military or something like that. And the reason for that, just so to my ears, what is civilian and what looks military is actually really hard. Take your example of food. A culinary specialist is a chief petty officer in the U.S. Army. It is thoroughly a military position. But it's cooking food. And so I do think that the way to deal with this, and this only affects obviously a narrow set of people, is to ask what did Congress have in mind in the roles that it was enumerating. Here, Congress had roles in mind like the one that Mr. Babcock does, teaching people how to fly military helicopters.
Where do you get all of that from the language?
We get
Tell
it.
me where
We get it from
where the language gives us those two requirements. First, that your job has to require you to be a member, and secondly, that it be one of these specified jobs.
Yeah, so I think
Just read the language to me and tell me where.
Right, so the language of the statute is service as a member of a uniformed service. So we think that has three components to it. One, got to be a member. Yeah, and here, of course, membership of the National Guard is required. Second, that you got to perform the statutory duties that are enumerated by the statute, as opposed to Justice Barrett's hypothetical, like adding some other duties that a private employer does.
A cook is listed. So what else?
Yeah, and then lastly, whether it's uniformed service or not, and that's defined by the statute, as I was saying to the Chief Justice in 410F.
So how do you exclude the chef? He's in the Army. He's a petty officer.
Right. I do think if Congress has defined that as a enumerated duty of the National Guard, then that person would qualify. Here, there are enumerated duties of the National Guard found in 709 and 10216, and as our brief explains, dual status technicians are integral to the performance of those duties. That's been said time and again by different people, members of the military, civilian officers, even the government's own briefs to this court in an admittedly different context. The Ferris context calls them irreducibly military.
Mr. Katyal, is training pilots to fly Black Hawk helicopters one of those enumerated duties?
We do think it falls directly within the enumerations of 709, which is organizing, administering, instructing, or training the National Guard or armed services and the like. So yes, we think it does fall that way. We don't think you have to get into any of that here, because Congress did use a pretty simple test, simple language that affects relatively few people. To the extent there's any doubt about this, we would suggest you apply the veterans canon, as Justice Alito's unanimous opinion for the court in Shinseki said back in 2011. If there's any ambiguity, read it in favor of veterans. And so we think that that would answer it. And I think, my friend on the other side suggests that there's somehow some sort of civilian bar in the statute, and I think this is implicit in the Chief Justice's question to me as well. But the relevant statutory language doesn't say that. It just says uniformed service.
Well, the way that Chief Justice read the language, I think, and this is the way I read the language too, is that we can sort of make this simpler by saying a payment based wholly on military service. Do you think that that's right? Is there a difference? If I say a payment based wholly on military service, is that the same as or different than this statutory language?
I think it may be the same. It'll obviously depend on how you read wholly. We don't think you should read wholly the way that they read it, to essentially say that there's wholly will modify service, which I think could be done.
Well, a payment based wholly on military service means that the payment has to be for entirely military service.
Exactly. So if that's the way you read it, Justice Kagan, we don't disagree. So people like Babcock, who spent their whole career in the dual status technician role and get a payment for that, that's a circumstance in which they fall within the exception. If we contrast that to a modified Mr. Babcock, someone who spent half of his time, say, working at the Department of Transportation in non-covered employment and half of his time working as a dual status tech, that person would not be eligible for the uniform service exception.
So if I understand what you're saying in terms of the way you read this statute, the only thing at issue is when he receives his paycheck, is it entirely for military service, or might it be for other things?
Is it entirely for uniform service? That's the one.
Now you're changing it, because I asked you, is it the same as for military service.
Oh, I'm so sorry. I didn't hear the last part then. So, so we do think there's a difference between uniform service and military service, and Congress gave you an express textual indication of that by enumerating the Public Health Service and NOAA as two examples. Those are people who are not military. The government, dances around this in their brief, but they certainly don't call them military because that'd be preposterous. Instead, what people like NOAA and Public Health Services folks are uniform service, and that's why Congress used that specific phrase. They could have picked up any other military test. As our brief says, there were all sorts of military pay stub tests throughout, including about the National Guard, like 709B and so on, but not this one. And so here Congress just simply asked, is the service as a member of a uniformed service? And to answer that question, you look to what is a uniformed service.
So are you saying, well, we concede that the payment is not entirely for military service, but it's all for uniform service?
We don't concede it. We do think if you went there, this is irreducibly military at the end of the day, but we don't think you have to get there. That is not the language of the statute. We think we meet the government's test, but we don't think the government's test is right. We think it's a simpler test affecting a very small number of people, but obviously people to whom this amount of money is really important.
Isn't it that, is there anything wrong with my reading the legislative history? Is there anything wrong where the statute's ambiguous? So, if I turn to a House report, which was so common and still is, where someone who works on the staff explains what they mean. And that explanation is run by all the senators, and either they or their staff sign off on it, and here no one objected. And what they seem to say when I read House Report 103, 506, whatever it is, at 67, I read it, and it seems to say that these smaller group of people who were actually in military reserve between 1956 or whatever the years were, they're the ones we're trying to help, not anybody else.
So Justice Breyer, we certainly don't have any problem with you looking legislative history. Some of your colleagues might, but we certainly don't. And we think if you look at it, you draw exactly the opposite conclusion, because Congress did say, you're absolutely right. Congress said military pensions focused on inactive service members and the like. The legislative history says that. But Congress didn't use those words. They used far broader words.
You're saying the person who wrote the legislative history got it wrong. The person who wrote that report didn't actually read the statute and didn't really know what the statute said.
Justice Breyer, there's nothing in there that excludes dual status technicians.
It says for a small, closed group of people who receive military pensions.
Correct, and we agree it is a small group of people either way, whether dual
based, at least in part, on non-covered military reserve duty after 1956 and before 1988,
Correct.
Which I admit I don't understand.
Correct. We agree that is the heart of what the statute is about. Our only point is the language Congress ultimately settled on doesn't have any of those terms in it, and once you start reading it the government's way, you're then into the problem of, wait, Congress then didn't do anything. It didn't cover even an active duty folks, which is, as you were saying, the paradigmatic case of what they wanted to cover. All right. Questions?
Mr. Katyal, when Mr. Babcock was working, did he get one paycheck or two?
So he got, when he was working as a national,
I assume he's retired now.
Yeah, so he got one paycheck for his National Guard service. When he went into active duty,
No, one paycheck for his National Guard service. Did he get one paycheck for his 9-to-5 job and one paycheck for the National Guard job?
I will let you, I just want to make sure what the record says. I'll get that for you on rebuttal.
But he does get two separate checks for pension, right?
Correct.
One for his 9-to-5 job and one for his National Guard
Correct.
job.
And the way that the statute works, it goes payment system by payment system. So it asks whether the CSRS payments are all wholly as a member of a uniform service or not. And then if he has, for example, state and local pension, that's a whole separate system and a separate calculation under the Windfall Elimination provision. You don't aggregate them together.
Just to be clear, I'm asking when he's working, at the end of the month, does he have, this is my National Guard check for the time I spent working as a National Guardsman, military status, right? But he had this separate, you will fight the separate maybe, but he also had the 9-to-5 job. Because that's what made him dual status.
Oh, yeah, no, I don't think he gets a separate paycheck for that. I think that's all one paycheck. It's just, I think his military service, to the extent he's on active duty or something like that, that is a separate paycheck. So I think those are the two paychecks. I will confirm this in the record.
Right, you say to the extent he's on active duty. Is it to the extent he's not, the National Guard has not been called up, but he's in the National Guard for specific periods, right?
Correct.
Okay.
Yeah.
So you're going to let me know if he got a separate paycheck for his 9-to-5 job and a separate paycheck for the time he was doing National Guard work.
Yeah, I'm pretty sure it's all the same thing because, he literally every time he's going to work, he's wearing the uniform and performing his National Guard dual status technician duties. I don't think there is any separate paycheck, but I just want to double check what's in the record.
Okay, thank you. Justice Thomas?
Yes, counsel, just a question as an aside. What would have been the difference in the treatment of petitioner if he had exercised the option in the 1980s to switch from CSRS to FERS?
Yeah, so if he elected to be in FERS, then he would be in covered employment, and then he'd be outside of the windfall elimination provision because it doesn't encompass, at least for those going forward years, non-covered employment. It only applies to non-covered employment. So once you're in the language of FERS and covered employment, you're outside of the windfall elimination provision.
So he exercised an option that put him in the current position that he's in.
Correct. And he, as he says, this is Petition Appendix page 44A, when he joined the service, he thought he was entitled to a certain stream of benefits. They then changed it on him. And yes, he had the option to convert, but conversion had all sorts of problems inherent to it.
Yeah, but that was true in the 80s for every federal employee.
Correct. And what Congress in 1994, Justice Thomas, said was uniformed service folks are going to get a benefit that other federal employees don't get. We want to benefit them in a certain way because they're seeing their paychecks slashed, as are, of course, civilian employees, but they wanted to do something, they wanted to do something for uniformed service folks. That was different and special.
Thank you.
Justice Breyer? Justice Mayor, anything further?
On this two checks, he got a check for his 9-to-5 job for the state National Guard, and he got a separate check for his inactive duty military service when he got called up for his 2 weeks or weekend duty. For the Army National Guard, he got a separate check, correct? And so he's being paid two pensions now, one by his 9-to-5 job, and he does get a military pension as well.
That is correct. That is what the uniform...
So that's the answer to the Chief's question.
I'm pretty sure it is. I just want to see what's in the record. Absolutely. Yes.
Justice Kagan? Justice Barrett? No? Thank you, counsel. Ms. Reeves?
Mr. Chief Justice, and may it please the Court. When a dual status technician retires, he receives two separate streams of payments, and the application of the uniformed services exception depends on the basis for each set of payments that he receives. First, he receives civil service retirement system payments from the Office of Personnel Management for the work that he performs in his full-time civilian role as a technician. Those payments do not trigger the uniformed services exception because they are based on his civilian employment. A technician also receives a second stream of payments, which are military retirement payments from the Defense Finance and Accounting Service for his part-time military service. That is, his inactive duty training and drills and his active duty service in the National Guard. Those military retirement payments do trigger the uniformed service exception because they're based wholly on service in a qualifying National Guard capacity. And petitioner and other dual status technicians like him, when they were in the role, received two separate paychecks with two separate leave and earnings statements. One was a paycheck for their 9-to-5 technician work, and the other was the paycheck for all their inactive and active duty service. Congress also repeatedly categorized technician service as civilian service, not uniformed service. First, Congress did not include dual-status technicians within the definition of a member of a uniformed service that is cross-referenced in the uniformed services exception. Second, in Section 10.216 of Title 10, one of the two primary provisions that governs dual-status technicians, Congress describes technicians as civilian 4 separate times. And third, in Title V, Congress defined technician employment as falling within the civilian service of the government and ensured that technicians would receive civilian retirement payments for their civilian employment. I think I'd start then by discussing a couple of points that my friend on the other side made. And the first is whether an individual knows what type of status they're in at any given point in time. And it's actually quite clear what status a technician is at any point. During his 9-to-5 job, a technician is doing work in the technician role. And in that role, he has a variety of benefits that he doesn't have while he's working in his National Guard role. And that includes the fact that he can join a union, he can file complaints with the EEOC and MSPB, he can receive compensatory time off and workers' compensation, and he's compensated under the federal GS system. That's different from his National Guard service, which he performs on weekends or if he's called up to active duty. Now, my friend on the other side has suggested that if you were to accept the government's position in this case, inactive duty service, such as training and drills, wouldn't trigger the uniformed services exception. And that's wrong because of a specific provision that deems such service as federal for the purpose of federal funding. And that provision is 10 U.S.C. 12602A, which provides that for the purposes of laws providing benefits for members of the Army National Guard of the United States, military training, duty, or other service performed by a member of the Army National Guard of the United States in his status as a member of the Army National Guard, for which he's entitled to pay from the United States, shall be considered military training, duty, or other service in the federal service. So let me unpack that a little bit. What that means is that when an individual is in his state status, which usually happens when he's doing inactive training and drills, because of this provision, he's paid by the federal government as a general matter, and that does in fact trigger the uniformed services exception because that payment is payment for qualifying service. Now, dual status technician service is different because Congress has categorized that service as outside the uniformed service and the payments for that service as civilian in nature.
Counsel, as I understand your colleague on the other side, and I may not, but as I understand it, as best I can in this area. We all understand that the National Guardsmen serve in at least 2 capacities. And one of them is denominated by the government for purposes of its own HR administration as civilian. And so, fine. He served as a civilian when he was working as a technician. That's how you classified it. But just looking at the language of the statute, and I think this is the argument in the simplest terms as I understand it, were the payments based, were they made wholly on service in the capacity of, as a member of a uniformed service? And the answer he would give is yes, because while you denominated civilian for certain purposes, you also said it could only be performed by someone who is a member of a uniformed service. So the work may be civilian for a bunch of other purposes, but it can only be performed by someone who is serving in the capacity of a National Guardsman. What's wrong with that argument?
I think there are a few things that are wrong with that argument. One is that a precondition to hold a given role doesn't render service in that role and payments for service in that role wholly for service in the capacity of the prerequisite.
Now, let me stop you there. Why not? Because if the work, civilian work, whatever words you want to put around it, can only be performed, has to be wholly performed by someone who is a member of the National Guard, why doesn't that take care of the word wholly for you?
So I think it writes out the word as, and the fact that we're in agreement, I think, that as means in the capacity of, and the fact that Congress...
Okay, but all right, so if we're moving from wholly now, we're putting that aside, okay? So you're not arguing on wholly, we're going to as, all right? And as, very important word in this case. I got that. In the capacity of is, I think, how that you would argue it is.
Yes.
Why isn't the civilian work being performed in the capacity of by someone who has to be a National Guardsman?
So I think in the capacity of and by someone that has to be are two different terms. And I guess maybe an analogy would be helpful here.
But the work is civilian work being performed as, okay, wholly as a National Guardsman. Why can't both be true, in other words? I know it's a lot to hold in one's head at the same time, that one could be both civilian and performing work as a National Guardsman. But what's wrong with that?
So they can't be because Congress has said they can't be. Congress has said that an individual, that there's something called National Guard service, and we pay individuals military pay and give them military pensions.
That's all over in Title 10, though. Here we are in Title 42. And what do you do just in Title 42 itself?
So I think in Title 42 itself, we looked at what is uniformed service, and we see that a member of a uniformed service is not a technician. And we know that when Congress wanted to include an individual who doesn't really look normal to us, who don't have expertise in this area, like a member of the PHS Corps or the NOAA Corps, it explicitly included them within that definition of uniformed service. And it didn't do that with technician.
So are we blowing past as now, and now we're on to uniformed service?
We're not blowing past anything. I think the best reading of this statute is looking at the entire phrase and giving meaning to the definition of member of a uniformed service, which doesn't include technician service, giving meaning to as, and the fact that service needs to be performed in that capacity, and giving meaning to wholly, and the fact that payments themselves have to be entirely or completely based on qualifying service. And we know
let me try it one more time, and then I promise I'll stop, because I'm beating a horse that's pretty dead, I think. Payments based wholly on service, okay, it's civilian service, based wholly on civilian service performed in the capacity of a National Guardsman. I think that's the reading, okay? I think that's as best I got it, and I may be completely off base. Mr. Koch will tell me. But what's wrong with that? Why can't we hold these two things in our head at the same time?
I think because of the definition of uniformed service, and I don't think we can just look at the Title 42 definition, because Title 10 is one of the two provisions that creates dual status technicians, and it refers to their service as civilian 4 separate times. Now, my friend on the other side has noted that they're referred to as military technicians multiple times, but that just refers to for whom they work. It doesn't refer to the nature of their service. So I think that we can't just read this in a bubble, and when Congress enacted it was enacting it against a backdrop of the fact that National Guard members do have different types of service, and that National Guard members, for the most part, are part-time service members. And I think it's helpful to compare the service that a dual status technician renders with two other types of service that the National Guard has. One is active Guard Reserve, and those are individuals who hold a full-time military role, and all of their pay for their 9-to-5 job receives the benefits of the uniformed services exception. And the National Guard also employs civilian employees who aren't members of the National Guard. And all of these individuals may perform service that seems to us to be very important to the National Guard and integral to its functioning. But what matters for the purposes of the uniformed services exception is how Congress chose to define the service. And Congress chose to define the service.
What about Mr. Kayal's point that there is a statutory list of duties performed by people like Mr. Babcock, and that list can be read to include Mr. Babcock's training, of pilots?
So the description he was referring to is in 32 U.S.C. 709, which describes what dual status technicians do on a day-to-day basis, and that includes organizing, administering, instructing the National Guard. And that is certainly what he did during his 9-to-5 technician job. We aren't debating that in any way, but that even though that's important to the National Guard, integral to its functioning, that was his 9-to-5 civilian service, and that's separate from his weekend training and reserve service. So I don't think the fact that Congress decided to list off their roles here tells us anything about whether that service is in the capacity of a member of a National Guard. And it's also important to note that Congress also has wholly civilian employees of the National Guard who aren't members of the National Guard and don't have that prerequisite. They can also be trainers like Mr. Babcock was.
What is the purpose of this dual status setup? Why would it not have been sufficient for these employees to be simply civilian federal employees? If they want to be in the National Guard on the side, fine, they could be in the National Guard.
So I can't answer that question as to any individual technician because there are tens of thousands of them and they do have very different roles. It might be a different answer for Mr. Babcock. The individual who was the plaintiff in Martin, the 11th Circuit case on this issue, was personnel clerk, so he did paperwork but still had to be a National Guard member. But I can tell you why we got here and maybe some of the benefits of it. As to the why, this is really a holdover of how states had structured the system before. So in 1916, Congress authorized states to hire military caretakers who are the predecessors of dual status technicians. And states developed a practice where most of these individuals had to be members of the National Guard.
Well, is this just a historical accident, or is there some benefit to the federal government or to the National Guard from having these people in a dual status as opposed to an overlapping status as opposed to completely discrete statuses?
So I think the benefits are that it definitely helps the National Guard with enrollment because these civilian jobs are very attractive with all the benefits that they have. And it also does help the National Guard from the perspective of cohesion and unit readiness. These individuals, do get called up with their National Guard units and do inactive training and drills with them. I don't think any of that really tells us anything about how to answer the question presented here, just because, as I previously discussed, what we have to look at is the status itself, as Congress has defined it, and the type of payments that Congress has provided for that, not whether it looks military or looks essential to us. I think, my friend, let's talk for a moment about wholly and what kind of work that term is doing here. We read wholly as an adverb that modifies the adjectival phrase that begins with based on, and that phrase in turn modifies payment. I think we're all in agreement on that reading, and what that means is that we have to look at the nature of this particular payment here. And I think even if the court were to accept my friend on the other side's functional approach, which says that this looks like National Guard service, so we should treat these payments as it for being payments that trigger the uniformed services exception, that doesn't work because wholly indicates that even if you're taking that functional approach, which we don't think you should, the payments are not wholly based on that. An individual member of the National Guard who's not a technician cannot receive these CSRS Civil Service Retirement System payments that petitioner received. He can't hold that technician role. And I think because of that, wholly does do work under our reading. And the problem with my friend on the other side's reading of wholly is it actually is reading wholly as in whole or in part. Petitioner suggests that if there was a CSRS payment that was partially based on military service and partially based on non-military service, that could somehow be apportioned out and only the part based on military service would trigger the uniformed services exception. But that's actually completely against the text of the uniformed services exception. And if this court were to find that dual status technician payments trigger the uniformed services exception, it would be the only situation in which a CSRS payment could be entirely based on military service and would be subject to the uniformed services exception. If the court has no further questions.
Further questions? Justice Thomas?
I have just a minor question. How big a problem is this now that CSRS no longer exists?
I could give you a partial answer as to the number of individuals that this will impact. So this will only impact individuals who are in the dual status technician role before 1984 and are still receiving CSRS payments or are eligible to receive them and are not yet receiving them. And because of data keeping limitations, I only have the number of dual status technicians who retired after 2004 or are eligible to retire, and that's about 53,000 National Guard dual status technicians. This case will also impact a smaller number of Air Force and Army technicians. Those forces have dual status technicians like these. It's a much smaller number because the force authorizations for those have been smaller. So that's unfortunately all that I can provide for you, but it's a fairly small group of individuals that this case will possibly impact.
Thank you.
Justice Breyer? Justice Alito? Justice Brewer? Okay,
So we agree this only impacts folks who are still receiving CSRS benefits that they would have been eligible for before 1984.
Yeah, based on service before 1984 or service that began before 1984
right.
and continued.
Yeah. All right. And then, secondly, if no man alive can figure this out, does the veterans canon have any role to play here?
So obviously I disagree with your premise there. I think that there are a lot of textual clues in this statute and in related statutes that indicate that our reading is the better one. But I don't think the veterans canon has any play here for a couple of reasons. The first is that the group of individuals that this would benefit, Congress has defined as not being veterans. And that's because technician service itself doesn't create any sort of veterans preference. It doesn't give someone veterans benefits. It's only the National Guard service that someone renders that can possibly give technicians veterans preference. So I don't think that would be an appropriate place to apply the veterans canon, because the veterans canon is usually applied to statutory schemes that themselves are intended to benefit veterans.
Military, not uniformed service. We're back to that.
I don't think it's back to that, because I disagree that technician service is uniformed service. Technician service isn't within the definition of uniformed service.
Sorry, I didn't mean to go back there. Thank you. Thank you, counsel.
You agree, however, that there is a veterans canon that would apply when statutes are ambiguous generally. You say it doesn't apply here, both because it's not ambiguous and because it's not really veterans as we normally think about it.
Yes, we are not contesting the availability of the veterans canon to resolve grievous ambiguity.
Justice Barrett? Thank you, counsel. Rebuttal, Mr. Katyal?
Thank you, Mr. Chief Justice. 3 points. First, as Justice Gorsuch was indicating, we do think that the plain text controls here. There are 2 key features of our argument. First, Section 415 looks to service, not status, and in particular uniform status service. And second, Congress has specifically defined National Guard service as uniformed service, and dual status technician service in particular as part of that, and has labeled it military. Second, Mr. Chief Justice, he got 1 paycheck for his DST service, his dual status service. That's Petition Appendix page 42A. That is, to be sure, a civilian paycheck under Title V. Our point is civilian, where your paycheck comes from doesn't matter for purposes of 415. 415 doesn't ask that, and indeed, as Justice Gorsuch was saying, it's not mutually exclusive. You can have a civilian paycheck but still be serving, your service may still be performed as a member of a uniformed service. There is no pay stub test. Congress has used pay stub tests even with respect to the National Guard, as our reply brief points out. Here they didn't do anything like that. They used the words service as a member of a uniformed service. They didn't try and embrace a paycheck test or anything like that.
Mr. Katyal, I'm sorry to interrupt your rebuttal, but I want to make sure I've got this right. Did he receive 1 paycheck for his civilian status duty and 1 for his National Guard duty?
No, 1 paycheck for it all. That is, his job is all part of one thing. So when he shows up to work as a dual status technician, he falls within all the requirements of 709, wearing the uniform, all that stuff. He doesn't have some separate hat he's wearing for purposes of 415. He's getting one paycheck.
Is it allocated separately?
Only to the extent, as I was saying before, he's in active duty or something like that. But otherwise, he's getting one paycheck. It is a civilian paycheck, but that's not what the test is.
What about weekend service, like when he goes for training and drills?
And the weekend stuff also comes in the military DFAS payments as well.
So that's the separate, like we could say it's two separate paychecks insofar as you're talking about his weekend National Guard service that you might do even if you were in private employment.
To the extent he was doing any of that, any weekends or something like that, that's military and separate. Now, my friend,
but that's military and separate. Does he get paid for that?
He does get paid for that. Absolutely.
Is that different than the pay he gets for his 9-to-5 job?
It is, because that's Title V. He does get two paychecks for, not for his dual status service, but anything else. So then my friend on the other side said that there's a statute that she's just pointed out, 12602, which says that she says it fills the gap and allows them to cover National Guard of the United States. That's not an argument they've made before in 27 years, but I don't think that statute actually works. Indeed, it's inconsistent with their own view of the word holy, because their own view of holy is that because they say Title V is responsible for these civilian payments.
So let me get back to this. Person A, Monday, Tuesday, Wednesday, works as a technician, nothing really, at the Army base, but does nothing that a civilian doesn't do there. Then on Thursday, he does a special National Guard duty, and on Friday they're nationalized, so he has a federal thing. He gets one paycheck for that week, is that right?
If he's nationalized, he would get a separate military pay stub and a separate military
Okay, so
paycheck.
for Monday, Tuesday, Wednesday, Thursday, he gets one paycheck.
Correct.
Now, okay, how do they deduct the Social Security for that? Because it goes to two systems, doesn't it?
It does go to two systems.
All right, so how do they do it? They deduct two amounts, one for the one day of Thursday and another for the...
No, it's system by system, and that's the way the windfall elimination provision works. So you only look to, and I was saying this in my opening work, you only look to, for example, the CSRS payments. Here, there's only one stream of CSRS payments. They're all wholly uniform services. So that's why we think he falls within it. Now, if there's any ambiguity in this, we would suggest that the veterans canon does apply, and the government doesn't argue, Justice Kavanaugh, that that Mr. Babcock and other dual status technicians aren't veterans. Pointedly, the last paragraph of their brief says the reverse, that they are veterans. And so if there is any ambiguity, we would suggest that you read it that way. And I think it'd be a very dangerous thing to fall on the 12602 argument that my friend has just raised, because it's inconsistent with what they say holy means, and also, indeed, it very well may boomerang on them, because it says if you're, quote, entitled to pay from the federal government, then that counts as federal service. Well, undoubtedly, Babcock is entitled to pay for his federal service, for his dual status technician service Monday through Wednesday. That makes him part of the uniform service exception.
Thank you, counsel. The case is submitted.